SJC-12925, Joshua Perrier v. Commonwealth.
Batson.
Good morning, Your Honors, and may it please the Court, Nicholas Massman, Joshua Perrier. This case raises the issue of the extent of protection that's available to a criminal defendant whose trial is terminated by the misconduct of the Commonwealth. The Kennedy rule set out by the Supreme Court in Oregon v. Kennedy sets out a minimum of protection under the 5th and 14th Amendments. But as I point out in my brief, has been widely acknowledged, the Kennedy rule as the totality of double jeopardy protection in this scenario where a defendant's trial has been terminated by Commonwealth misconduct is woefully under-inclusive and woefully inadequate to protect legitimate double jeopardy rights. And so I am asking the Court to recognize broader double jeopardy rights in the context of where a defendant's trial is terminated by prosecutorial misconduct or negated by prosecutorial misconduct.
Isn't Donovan pretty clear that we're not going to provide that extra protection? And it's done in the context, I mean, the U.S. Supreme Court issues the Oregon case, sends it back to Oregon. Oregon actually creates a greater protection under its own law, and it's sort of a famous state case. And then we don't do it. We do the opposite. We say expressly we're following Donovan and we're not providing greater protection. Isn't that kind of the end of the story? I mean, we thought about it. We have a very, good decision from Oregon. If we want to provide greater protection, we don't do it.
Certainly, Judge. Well, I would say that by its nature, the common law evolves with the time. And
Right.
One thing that this Court could certainly consider in the 20-some-odd years that's passed since Donovan is that both lower federal courts, federal appellate courts, and a number of state courts have, even in the time since Donovan, recognized that the Kennedy rule is not sufficiently protective. And so, while certainly there is language in Donovan that is relatively clear that at that time, given the facts of that case, that they are not prepared to recognize any broader protection, I would say that the Court can certainly adapt the common law as there's more experience both within and without the Commonwealth in dealing with these issues.
Counsel, does it at all matter that that the predicate isn't there of a mistrial being ordered by the trial judge?
I'm sorry, Judge, I missed that. Could you?
Sure. Does it matter that the trial judge, when you're asking for the more expansive protections, does it matter that the mistrial was not ordered by the trial judge?
No, it does not, Your Honor. And the reason for that is, and this has been pointed out by several of the state court cases, particularly I would refer the Court to the Batts case, which is a California case cited in my brief, where they note that cases where a mistrial has been granted do not exhaust the possibilities of a violation of double jeopardy. There can certainly be violations of double jeopardy where the Commonwealth, for instance, you could have, if you imagine the prototypical Kennedy situation where a district attorney with intent to goad a defendant into a mistrial, commits misconduct. If that mistrial motion is allowed, there's double jeopardy protection. If it's not, but the prosecutor prejudices the defendant in front of the jury such that the jury that the jury convicts where they might not have, you still have the defendant being wrongly deprived of the finality of acquittal, which is what, writ large, the double jeopardy principles are trying to protect. So if double jeopardy is limited to only those situations where a mistrial has been granted, the result would be under-inclusive and arbitrary enforcement of double jeopardy protections. So it needs to be broader than that.
Well, then going backwards from that, then if you're looking at the triggering conduct, the cases that you rely on, they're not this. They're not this case. So I'm a little bit troubled by looking at the record of what happened here, where it seemed to be really just an innocent misunderstanding of the trial judge's ruling, that the trial judge considered and made findings that it wasn't intentional, it wasn't trying to goad into a mistrial, that it was just a misunderstanding, it was a mistake.
Respectfully, Judge, I would suggest that the trial judge did not find that it was unintentional, that the argument was unintentional insofar as it was a product of mistake or accident. And I think if the judge had found that, which I don't believe he did, intentional in a general intent sense, in the sense that the content of the argument was intentional. I don't think the judge found that. And if the judge had, I think that would be clearly erroneous, given the facts of this case. There was a clear motion in limine. The district attorney said at the time, here's what I want to argue in closing. The judge said, I understand you, I hear that, but I'm allowing the motion in limine. The district attorney makes that exact argument with a slightly different theory of how it was admissible. That I would say was an unreasonable interpretation of the judge's ruling.
I have the same issue that Justice Georges did. I want to be able to apply the right factual predicate, because that's not my understanding at all. Like Justice Georges, I thought that the trial judge was saying that it was a mistake, it didn't constitute deliberate, intentional, or egregious misconduct, and that's completely understandable response because there was concern that someone 19 has a lower BT, and all she's doing in argument is drawing inferences about conduct based on age. And quite frankly, I'm not sure it fell within the prohibition.
So, Your Honor, I think it's important to, well, stepping back, if you look at the judge's findings, he did make findings that it wasn't, I think as he phrased it, sufficiently intentional, deliberate, or egregious to give rise to presumptive prejudice. It wasn't sufficiently intentional, egregious, or deliberate to hold the Commonwealth in contempt, and that it wasn't motivated by a specific intent to goad the defendant into requesting a mistrial.
So then why isn't Justice Georges right that this is just not the right case to determine whether you need to have the Lamb-Hugh 2 goading be a requirement of goading the defendant into a mistrial, and that these facts just don't raise the issue as to whether we should revisit Donovan?
I think there's an important distinction here between a general intent to make an offending argument, and a specific intent what's motivating that misconduct. I think the Batts case in California is a good example because it's fairly analogous to the facts here. In that case, there was a pretrial evidentiary ruling excluding certain evidence. At some point, the district attorney in that case felt that the defense attorney had exploited that ruling to create an inaccurate representation to the jury. So during a break in cross-examination, the district attorney went to their witness who was on the stand and said, I'm going to elicit from you this evidence that the judge excluded.
You have a tough road to hoe, given a clearly erroneous standard in the judge's facts on the ground. I mean, here we're dealing with the age of the defendant, which the jury can see, right? Doesn't it hurt? Does it hurt? I mean, he said here's a young kid who's impulsive, and guess what? In front of him is a young kid who's on trial.
Yes, Your Honor. The distinction and why the defense filed and argued the motion to eliminate was to present the inference that there's a lower standard that applies when somebody's under 21. Certainly, the jury can look at the juror and go, that's a young gentleman. The difference, though, between a 22-year-old or a 23-year-old and a 20 or 19-year-old is not something I would expect the jurors to be able to distinguish with that granular effect. And that is where the prejudice lied in this case.
But your prejudice seems awful speculative, given the serious nature of the allegations you charge against the prosecutor.
I respectfully, Judge, I disagree. The judge found, there's a motion to eliminate, the judge found that this would be under Rule 403, that the prejudice would substantially outweigh the probative value. And the DA made that exact argument. It's worth pointing out here that if the district attorneys thought, well, hey, hey, trial judge, your ruling was limited in this fashion, which is what she alleged in her brief, which was not how the judge allowed the motion or what the motion, the relief the motion asked for. But if indeed she thought that, there would be a very simple expedient here, which is, Judge, can I approach sidebar?
It's called a mistake, right? And that's what happens at trials. Mistakes happen.
Certainly, Judge. But this particular mistake, where the judge makes a finding that, a ruling that certain evidence is prejudicial, and importantly, not able to be cured by a limiting instruction, because the Commonwealth asked for reconsideration, citing that argument, and the judge rejected that. If the district attorney then makes that exact argument, putting those exact facts before the jury, asking the jury to imply that the defendant is under 21, based on, not on the fact that she listed, but on.
No, I get your double jeopardy, as Justice Kafka brought it out. I get your double jeopardy argument in your well-done brief that says we're not doing enough in the scourge of prosecutorial misconduct. The problem you've got is that's an awful lot to carry on some facts that really aren't as troubling as maybe you think they are.
I'm going to follow up with Justice Gaziano's point because you were cut off before you were making your point. You said this was analogous to Batts. This is not analogous to Batts. I mean, the prosecutor made a concerted decision to go to the witness and say, I'm going to ask you questions that are going to elicit an answer that the judge told me that I cannot do. And I'm going to do it because I'm annoyed that the defense counsel seems to be taking advantage of it. So this is apples and oranges to Batts. This is if a trial judge said to me, at the time of the date of offense, the defendant was 19, and defense counsel filed a motion said that I don't want any reference to the defendant's age of being 19. And the judge sanctions that and says, you're okay, allowed. But then there's the prosecutor brings out testimony that the defendant was young or looked young. Isn't that a good faith misunderstanding that it's not just 19, but it's anything at all that refers to the youth of the defendant? And that's what happened here, isn't it?
Respectfully, Judge, no. What happened here was there was a clear ruling that the motion was phrased as to preclude any reference to the defendant's age as being any reference to the defending age. In arguing the motion, defense counsel said, anytime there's a reference to my client being under 21, that raises prejudice. The judge allowed the motion, agreeing with the defendant's argument, and the DA in this case, in theory, understanding all of that, said, well, the judge only allowed the motion as to the age of 19, which the judge never did. If you look at the record, he allowed the motion as it was phrased and as it was argued.
Right, but that's what I'm saying. I guess we're just disagreeing on this, because somebody could say age meaning the number, the numerical number, and not any reference to being young, inexperienced, youthful, whatever. That he allowed it as to the number, and that's why I'm saying that this is a tough set of facts to say that if we're not doing enough, this is the case that we have to now say we're going to do more.
Well, Your Honor, what I would say to that is I don't think, if you look at how the motion was phrased, how the motion was litigated, I don't think it would be reasonable for the district attorney to understand that although the age of 19 would be more prejudicial than probative, particularly where the defense counsel raised the point that the issue is the references to him being under 21. I don't think that the district attorney could reasonably understand that while his specific age is more prejudicial than probative, I can explicitly ask the jury to infer that he's under 21 and avoid that prejudice. I don't think if you look at the motion, how the motion of limb was litigated, how it was argued, I don't think that is a reasonable interpretation of the judge's ruling. And with my time running short, I would just raise one last issue, which is even if the court declines to recognize further protection under state law, there's a sort of residual question about whether this court under federal law should adopt the analysis in the Wallet case, the Seventh Circuit in the Catton case, also recognized additional protections where there is not a mistrial granted, which would be the facts here. Thank you, Your Honors.
Thank you, Mr. Mattson. Mr. Townsend?
May it please the court, Thomas Townsend for the Commonwealth. This was a mistake. The defendant filed a motion in limine, it's on page 14 of the record, motion in limine to prevent reference to the defendant's age. The prosecutor took that to mean do not elicit testimony as to the defendant's age of 19. And she took contemporaneous notes on her copy of the motion, not to elicit testimony as to age of 19. In his opening statement, defense counsel referred to the defendant as a young man. The prosecutor later, in her closing argument, referred to the defendant's youth. There was an objection, went to sidebar, and the prosecutor immediately said, it was almost an excited utterance, Your Honor, your ruling had to do with testimony. This is argument. And the judge said, no, no, no. I meant to include any reference. The prosecutor said later on in the motion for a new trial, she explained how she made the mistake, and she said that the defendant's appearance is evidence. I took that as I could argue his appearance, but I couldn't elicit testimony. And in my opposition to the motion for a new trial, which is in the record at page 323, I cite the case law into the Massachusetts Guide of Evidence, section 1113, which says the appearance and demeanor of a person in a courtroom is evidence, even if the person does not take the stand. So it was an honest mistake by the prosecutor. And the judge so found. The defendant says, well, there was no explicit finding. I disagree with that. On page 2 of his written decision, denying the motion to dismiss, which is located at page 37 of my addendum, the judge explained why he was not going to use the double jeopardy bar to prevent a retrial in this case. And he says, quote, even if in the event the current rule was to be extended to include cases which no mistrial was declared, the Supreme Judicial Court has declined to extend it to include unintentional prosecutorial mistakes. So that's what we have here, an unintentional prosecutorial mistake. I think the record is clear on that. And it's not clearly erroneous. This was the trial judge. He heard the motion, both the motion for a new trial and the motion to dismiss. He heard the prosecutor's explanation at sidebar in the heat of the moment. He heard the prosecutor's explanation at the motion for a new trial, where, as an officer of the court, she addressed the judge and explained how she had made the mistake. And that's what it was, a mistake. And the double jeopardy bar was never intended to reach mistakes. That, indeed, was the exact argument that the litigant and Donovan argued. That, too, included an unintentional prosecutorial mistake. And that was the argument, citing the same cases the defendant today cites. And this court found those cases to be not applicable because they involved intentional misconduct, whereas in Donovan, it was unintentional. Here, likewise, it's unintentional. And I agree it's a common law rule and can be adapted to meet the evolving times and changing circumstances, but there should be some showing that the current rule is unworkable or has proven to be unworkable. There are very few cases raising a Donovan claim, and I suggest that that shows that this is not an unworkable rule. I pretty much covered the waterfront in my brief, pages 22 to 23, citing to those cases. There's not a whole lot out there. There's not a whole lot of claims.
There are a lot of out-of-state cases that don't like the rule, right? Where states have provided greater protection on top of that. I'm not saying we should do it, but there is a lot of dissatisfaction out here when we look at the case law.
Right, in the highest courts in those jurisdictions may perceive a rule of prosecutorial overreach and overzealousness. And
Can I ask you a separate question? So you have a number of ways of winning. You can win on just the basic fact-finding, which seems to be very, very solid. You can also, do we have to decide the issue of if it weren't granted? If the motion for a new weren't granted? I think that's sort of the trickiest issue, at least from my perspective at this point.
I understand Your Honor's question. That's why I led with the factual issue.
Right.
There's no need to get to the legal issue, which may, under the right set of facts in another case, present an interesting issue, an interesting question for this court. Here, the judge found it was unintentional prosecutorial mistake, and there's no reason
Yeah, I'm just
that-
trying to figure out, imagine a situation where the judge just makes some comments, well, I think you're trying to goad this, but I'm not granting it. What do we do then? Or do we not decide that today?
Well, goading would fall right on the lap of the.
But don't you have to get your motion granted too? That's the.
Well, that would be the question for the future case. So if you do have a case where there is intentional goading, but the motion to or the mistrial is denied, it's not reserved for post-verdict, it's denied on the spot. I would argue, in Oregon versus Kennedy would back this up, that the right that's being protected by the double jeopardy clause in that situation is the right to have the defendants, have the impaneled jury decide the defendant's case. So if it is denied, he's still getting the impaneled jury to decide the case, whether it's guilty or not guilty or hung jury. That's the right that's being protected in Oregon versus Kennedy, and the Supreme Court was very clear about that. Now, there's other courts that say, well, maybe we don't have an intent to gold, but perhaps we have an intent to torpedo a sure acquittal. And there are certain cases will say, well, if it's an opening statement error, well, there was no attempt to torpedo an acquittal there because it was the beginning of the trial. Or if there were a strong case for the prosecution, there's no intent there. But all these issues can await a future case. This is not the case. I mean, Donovan has proven workable. Massachusetts prosecutors, to their credit, are not trying to gold mistrials. There's really no viable Donovan claims in the 24 years since Donovan. The only case I can think of is where a judge actually found Donovan as a bar. It was the Curtis case. That went up to the appeals court, and Justice Lenk on the appeals court reversed it and said there was no intentional misconduct. Other than that, I'm unaware of any prosecutorial goading that would give rise to a double jeopardy bar. And it's certainly not present in this case. And unless the court has any further questions, I'm willing to rest of my brief.
Thank you, Mr. Townsend.
Thank you very much.
Court, all rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Justices of the Supreme Judicial Court, now sitting at Boston, within and for the Commonwealth, at present part, the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts. Court is adjourned. Thank you. Please remain standing as the justices exit. Thank you.